Hello and welcome to Narayana IAS. I'm Pratik, your faculty for Polity, International Relations and Security. Students, today we are going to discuss a very important topic, and the topic pertains to the decision given by the Supreme Court. And what is the decision? The decision is that the Supreme Court upheld this law, Uttar Pradesh Board of Madrasa Education Act of 2004. This law was challenged in the Supreme Court regarding the constitutional validity of the law. The Supreme Court upheld that this law is constitutional. So we'll understand the interpretation of the Supreme Court as well as the implication of the Supreme Court on the religiously established educational institutions. First and foremost, let's try to understand the basics. What exactly is this act? Now, this act was framed in the year 2004. What this act does is, see, Uttar Pradesh Board for Madrasa Education, which means it regulates the madrasas in the state of Uttar Pradesh. What are madrasas? They are educational institutions meant to provide education. Simple, right? So these madrasas, they provide education. Now, in order to regulate the madrasas, this act was framed, and under this act, a body was constituted. And what is the name of the board? Uttar Pradesh Board of Madrasa Education. When I say that this act regulates madrasas, which means this board will regulate madrasas. Now, regulating means deciding the curriculum, exam quality as well as teacher qualification. This is what this particular board does. It decides the curriculum, exam quality, teacher qualification, etc. It regulates madrasas in the state of Uttar Pradesh. The purpose of this act is to, provide religious education as well as secular education. What is secular education? For example, modern education like science, then we have maths, physics, etc. So this act, allows the madrasas to be regulated, right? Now this board comprises mostly of Muslim, right? But the purpose is to provide religious education as well as secular education. I hope you understood the purpose of the act. Purpose is to provide religious education as well as secular education as well as to regulate the madrasas in the state of Uttar Pradesh. Now, in the year 2019, right, one of the teacher in one of the madrasas of Uttar Pradesh challenged the 2004 act. So, in the year 2019. Why? Because this teacher in one of the madrasas was not getting the same payment as the other teachers were getting. This was a petition. At the same time, there's a broader question, and the broader question was with respect to the role of the religious board for education. I hope in the previous slide you remember that there's a board constituted to regulate madrasas. The broader question was raised with respect to a board supported by the state, and this board was imparting religious education. The Allahabad High Court said that the 2004 Act is unconstitutional. It is unconstitutional. It goes against the constitutional principle. Why? Because it breaches secularism. I'll explain you what is secularism, right? So the ruling of Allahabad High Court was that this 2004 Act is unconstitutional. Why? Because the Allahabad High Court said that how can a board funded by the state promote religious education, Islamic teaching? That's the reason the Allahabad High Court in the year 2019 held that the 2004 Act is unconstitutional. This decision of the Allahabad High Court, wherein it ruled that the Act is unconstitutional, was challenged before the Supreme Court. Was challenged. Now the matter goes in the hands of the Supreme Court. Now there were two issues in front of the Supreme Court. There were two issues. One, whether the State Board for Religious Education, this board was established under the 2004 Act. Whether this board established under the 2004 Act is compatible with the secular principles of the Indian Constitution. Is it compatible? Is it alignment with the secular principle, or this board violates secular principle? Allahabad High Court said that it violates secularism. The question was whether this board established under 2004 Act violates secular principle. At the same time, whether such boards which provide religious education, do they have to meet the requirement under Article 21A, right to education? Which means, under right to education, it provides free education to children, right? Which means, does such type of boards for religious education have to meet the requirement under right to education? There are certain rules under RTA, that is, in between 6 to 14 years, right? Education has to be provided free of cost. So whether such boards have to abide by the rules under Article 21. So this was one question, one issue before Supreme Court. The other one was, now this madrasas in Uttar Pradesh were also responsible for awarding higher degrees. For example, Kamil is for the graduation and Fazil is for post-graduation, which means the madrasas were also giving higher degrees. The question was whether the madrasas can give higher degrees to the students. These were the key issues before the Supreme Court. Now, what was the Supreme Court decision? That the 2004 Act is constitutional. It is constitutional. It said that the Act does not violate secular principle. Now, please remember what the Supreme Court say, that secularism, what is secularism? Which means that state won't discriminate against any religion. The state won't have any official religion. The state will see all the religions equally. But the Supreme Court said that secularism does not prevent the religious or every religion to establish their religious institutions. Secularism is not preventing any religion from establishing their religious educational institutions. Why? Because Article 30 of the Indian Constitution allows the religious minorities like, Muslims, Sikhs, Christians to establish their educational institutions. This is a constitutional provision that the religious minorities can establish educational institutions. Which means secularism doesn't mean that we are stopping religions from establishing educational institutions. And the Supreme Court also held that the 2004 Act, under which this board was constituted to regulate madrasas, is also not breaching the secular principle. The Supreme Court said that as long as the madrasas are they provide religious education, as long as they are also providing secular education, modern subjects, it is not violating secular principle. This board is supported by the state, but if they are giving secular education, which means it is not violating the secular principle. I hope you understood the Supreme Court ruling. The Supreme Court also held that the authority of madrasas to award higher degrees like Kamil and Fazil is unconstitutional. It is unconstitutional. Why? The Supreme Court said that the authority to award higher degrees lies only with University Grants Commission. This UGC, only this body has the authority to award higher education. The power of madrasas to award higher education is wrong, unconstitutional, which means the madrasas will now not be in a position to award higher degrees. This UGC, it regulates, what it does is, it regulates higher education in our country. And so now the Supreme Court said that madrasas cannot give higher degrees. This was a Supreme Court decision with respect to the 2004 Act. Now let us try to understand the observation with respect to religious instruction and state funding. Now see, Article 28. What is Article 28? It prevents the children from taking religious education. Which means, let's say for example, if a person is studying in a school established by a religious minority, let's say Christian, and if that student is not interested to participate in the religious prayers, he is free to do it. Article 28 frees a person from taking religious education. He can say that I am not interested to, recite the prayers. Article 28 allows a student to free himself or herself from religious education or religious prayers. Which means, what the Supreme Court said is, see, there are two types of institutions. One, recognized by state, and second is non-recognized by state. Non-recognized, they are free to, regulate their own education institutions. The state won't interfere. The state is not recognizing. For example, let's say if such non-religious or non-recognized institutions, they award degrees to students, such degrees, no university, no company will accept it. Recognized by the state, which means either they can be funded by the state or state is recognizing their educational or religious education institution. Now here the Supreme Court said that if the madrasas are funded by the state, if they are funded by the state, then they have to ensure that along with religious education, they are also giving secular education, that is modern education. This is what the Supreme Court said. If let's say for example, if a madrasa is funded by the state and that madrasa is only focusing on religious education, this is unconstitutional. Which means the state cannot promote any one religion. I hope you understood the essence of this particular observation, that a student is freed from accepting or taking any religious instruction or prayers. He is free to say that I do not want to take part in the religious prayers, if that madrasa is funded by the state or recognized by the state. Now, what is the implication of the Supreme Court decision? This is very, very important. We have to understand the implication of the Supreme Court decision. First and foremost, this decision of the Supreme Court makes it very clear that the religious minorities have the freedom to establish education institutions. One. At the same time, the state also has the power to oversee the functioning or mechanism of the education institutions set up by religious minorities, which means it is balancing the state oversight and autonomy of religious educational institutions. Religious minorities have the freedom to establish their educational institutions, set the curriculum, teacher qualification, etc. But the state also has a power to oversee it. The state will see if all the things are going as per the rules and as per the guidelines. The second implication is that the religiously or the educational institutions established by religions, they have to make sure that along with religious education, they also need to focus on secular education, religious education and secular education. If an institution established by religion is funded by the state or recognized by the state, then that institution has also to focus on secular education. It is very important to ensure that secular education is also imparted. This is the essence of the Supreme Court decision, which means now this Supreme Court decision will serve as a precedent example to all the institutions established by the religion to ensure, one, that along with religious education, secular education is also given. Secondly, the religion based institutions cannot award high degrees, and also the state has the power to regulate or oversee the educational institutions. Students, I hope you have understood the topic in its entirety. If you have any questions, I request you to please post these questions in the comment box. We'll try our best to answer your questions. Right? This topic again is very, very important for UPSC examination, no doubt. At the same time, for the general audience, public, to understand what exactly is the act and why the Supreme Court upheld the particular act. Right? So I hope you understood. Now, I'll call it a wrap. Thank you so much for watching.